Somesh, let me admit for the first time, I also, as a fellow company secretary and a lawyer, believe me, after hearing both of you, the learned experts, also, still there are so many plethora of queries that remain in the mind, so much of confusion that is there. My high level view is that PMLA, which was earlier meant for uh, BFSI sector, banks, financial institutions, lending agencies, etc., suddenly by virtue of bringing the lakhs of chartered accountants, company secretaries, and CMAs on par with reporting entities, which are banks and NBFCs, which are big and organized. There's a huge confusion, Sumesh and Mr. Dalmia. The fact that how can individual now is expected to register with the FIU and give monthly reports and with no tools, no access, no mechanism, how suddenly it's like a child having been given robes of a robot and now he has to now walk with those heavy armor suddenly without preparation. This is my initial sort of reaction. What I would love to do is I would love to display the notification there and also seek your views. And initially I'll start with my questions, and then also there are many questions which have come up. So allow me a second. Yes. Now, these are the notifications. The first notification is 3rd of May. I want to just dwell. This is bare law I'm now displaying. And I want to just make certain things clear for myself and for the other hundreds of people joining in this webinar today to hear experts like you, Mr. Dalmia and Somesh.
Here, I would like to add one thing. If you are looking at the notification,
yes, sir.
Notification, it's not only CAs, CS, and ICWAs who have been covered.
Right.
These all types of professional and individuals who are into this particular business have been covered. Please try to understand.
Right.
Kindly read the explanation one.
Right.
For the purpose of this notification, relevant person includes. Relevant person includes. The thrust is on the word includes.
It is not an
inclusive definition. It is not an exhaustive definition.
Understand.
So these three are the examples, and rest will also be covered. That includes the advocates and other professionals who may be involved with these kind of activities, like creation, operation, and management of companies. Like there are certain websites on the internet who are into the business of providing directors and who are also into the business of creation of companies, formation of companies, etc.
Right.
They all will be covered. It is not only limited to CAs, CS, and ICWAs.
Understand. No, very good point, sir. And I want to just start from here. The notification said the central government hereby notifies that the financial transactions carried out by a relevant person on behalf of his client in the course of his or her profession in relation to the following activities shall be an activity for the purpose of said subsection. So the activities are buying and selling of immovable property, managing of client money, securities assets, managing of bank savings securities, organization of contribution for the creation, operation, or management of companies, and creation, operation, or management of companies, LLPs, etc. Now, this has been saying that in exercise of the powers conferred under Section 2(1) SA 6. I want to just throw your attention here on 2(1) SA. It says, this is the definition. It says, person carrying on designated business or profession means person carrying on such other activities as a central government may notify. So by that notification, central government has notified those activities. Therefore, it falls under the definition of person carrying on designated business or profession. Now, anybody who's doing those activities is a person carrying on designated business or profession. And I just want to highlight here, reporting entity. Reporting entity means a banking company, financial institution, intermediary, or a person carrying on designated business or profession. So by virtue of this definition, those activities, whoever does that is a person carrying on designated business or profession, and any person who carries on those activities becomes a reporting entity. So therefore, the entire act, which was casting obligations of due diligence, reportings to reporting entities being banks and financial institutions, also apply to those people who are carrying on these activities. This is how, by virtue of simple notification, by change in the definition, suddenly lakhs of people, including professionals, and Mr. Dalmia has highlighted, including CA, CS, CMAs, but not, I mean, there could be other people doing these 5 activities also added. Yes, Somesh, you're saying something?
No, I want to say that REs are obligated for registrations, reportings, right? So government is expecting that I am providing you the support for combating, means you are the soldiers in terms of financial terms, right?
Right.
Of this, and they can provide you the MMGs, LMGs, other guns, but you should to know how to use that. That is very critical and utmost important in today's digital world. So that's why they are empowering you. They are giving you all the technology support so that you can combat it. And I already discussed last point, financial transaction carried out by a relevant person, be it is a practicing professional. I am mentioning in the rules also, is mentioned in the maintenance of record rules. Your supporting staff, who are the paralegal guys, who are the accountants, who are your HR staff, that also be covered under the relevant definition.
Sure. Question to any of you, Sumesh and Mr. Dalmia, is that it says the financial transactions carried out by a relevant person on behalf of his client. Now, if a practicing professional is creating a company or operating a company or a company, he may his in that company. Or are we saying that if you're creating a company but also putting in some share capital, or there is an exchange of
in legal we have seen client is giving you professional fees, party payments, because you have already incurred such expenses, but that expenses are not paid by the client but paid by some other third party. So that kind of transaction you should highlight, and you should review it in your firm, why that client has given that money from another account.
Any comment?
Sumit, in my view, the fee will not be covered. Fee is not a financial transaction.
Right.
Financial transaction has to be read in conjunction with the points 1, 2, 3, 4, and 5. That is buying and selling of any immovable property. So if the client is giving you the money for buying a property for and on his behalf,
right,
managing of client money. Now, if the client is giving you the money to invest in share market, like those kind of services, management of bank savings and securities account, in that particular case, it can fall into the category of financial transaction. Otherwise, plain simpliciter receiving professional fees will not fall into the category of financial transactions.
No, very well said. And therefore, even creation, operation, or management of companies, only if the practicing professional has a role in the financial transactions of the client company, I think then that will be covered. But plain vanilla incorporations should not be covered.
I don't agree, because they have specifically, this you have to take from the perspective of the Chinese companies who have created, committed havoc in the financial world here in India, who have also indulged in money laundering activities. Here the words are, you read 1, 2, 3, 4. 1, 2, 3, 4 points are different from point number 5. Point number 5 is simply dealing with creation, operation, management of the company. So if you are creating the company for some client, for operation and management is slightly different. But creation here, you have to read, means formation of the company.
But Mr. Dalmia, here it says notifies that the financial transactions carried out by a relevant person in relation to the following activities. So where is the financial transaction here in creation of a company, other than the fees that they receive for creation?
Hold on, let us read it again. Hereby notifies that the financial transaction carried out by a relevant person on behalf of his client in the course of his or her profession in relation to the following activities. Now, when a person is creating a company, the person may be paying the government fees, after taking it from the client or maybe from his own pocket. The idea is to curtail this particular tendency of formation of frivolous companies, fake companies.
Right. Sure.
So the words are little bit different. These words may be loosely drafted also, but
Right.
we have to go behind the real intent. And real intent is financial transactions relating to creation of companies.
Understand. So I think the message that is coming out is plain vanilla incorporation and taking your fees may not be sort of bad or regulated. However, if you're routing, if you're taking say lakhs of rupees as on behalf of the client, or maybe paying on behalf of the client maybe in the garb of some statutory, means normally certain fees is paid by the firm, they're reimbursed. But sometimes it may be huge stamp duties. It may not be exactly what you receive, what you pay, and why you pay, etc. So if there are certain financial transactions which are being done by the practicing side or by any person on behalf of the client, that may be under the radar of PMLA. That's what broadly the message is coming out to be.
And Sumit, last thing I am highlighting, financial transactions means two words, and the transaction itself defined in the maintenance of record rules. And transactions mean even if you are carrying out for corporate any gift deed of shares transfer, that transaction also be covered because fund has not been moved, but it's in a financial transaction. So transaction is widely defined in the transfer this PMLA rules 2005.
Understand. Okay, the next notification was 9th of May, which says now it doesn't contain the word transaction. It says the central government hereby notifies the following activities when carried out in the course of business on behalf of or for another person, as the case may be, as an activity under the same subclause. So the clause that I showed you, these additional 5 activities have been included if it is done by anybody on behalf of another person. So acting as formation agent of companies or LLPs, acting as a director or secretary of a company, partner of a firm, etc., providing a registered office, business address, accommodation, correspondence address, etc., acting as a trustee for an NGO, or it could be even probably a director of a Section 8 company, acting as a nominee shareholder for another person. Now, this is very, very important. Again, thousands of professionals being CS, CS, CMS would be providing registered office services to their clients. Because it may be a foreign client with no place of business in India, or it may be a new startup who may not have taken a place of business, and they would need, and these are very legit services provided globally, even companies in Singapore, companies in Mauritius, practicing people, including the big law firms, I would say, on record, would lend their offices in a very legit way as their registered office or a correspondence address, or even certain people would be non-executive directors on their client companies for a professional fee or a sitting fee. Now, what is bad in that, and why? My first question is, what is meant by on behalf of another person? So if I'm acting as a director in a company, I'm acting a director in my professional capacity, but I'm not acting on behalf of another person. I'm acting on my own behalf. That is, so I'm not very clear on what is meant by on behalf of another person. Similarly, if we provide a registered office here, and then the exception says if you have signed a lease deed or a sublease, then that is okay. So it's slightly confusing. If anyone could clarify.
Okay, let me put it. In 3rd May notification, the word profession has been used. In the 9th May notification, the word business has been used during the course of their business. Right? That is one thing. So here they are not targeting the professionals. Secondly, why the word director is coming here with reference to particularly foreign companies. Now, what is happening that people are lending their names as directors, because when a foreign company is being incorporated in India, the compulsion is that you need to have an Indian resident director.
Right.
Right. So what is happening that they don't find an Indian director, Indian resident director. What is happening? People are lending their name. So they are into the kind of business of providing their name. It is not professional activity.
Sir, with due respect, for example, tomorrow a client comes to you and says, Mr. Dalmia, would you like to be a non-executive director in my company? Because of course I need one resident director, and you say and you consent to it. There could be some nominal fees, but then you attend the board meetings, you provide your legal expertise, you provide your overall experience and expertise in running the corporate governance of that company, and you review the balance sheets and you do the board meetings the way they should be done. And ensure that as a conscious keeper of the Indian law, because they are a foreign company, there could be foreign directors, but you are the Indian director and the conscious keeper. What is the harm in lending that name?
There is no harm at all. But when there is only lending of name, that they want to cut it.
Sure.
When you are into the business, means if you are a director in a company or two companies, that is okay, you report. But when you are into so many companies, that is the maximum possible companies where you can be a director, it has become a kind of business. That is what they are trying to prevent.
Sure. Understand. Somesh, any views?
In short, I can say that being a regulated entity, these practicing professional should take care of all the transaction, because the PMLA work, PMLA Act or rules only revolves around the word transaction. Maybe it's a financial, non-financial, but obligation is to review your transactions. That's it from my side.
Understand. All right. So now couple of more questions. So Somesh, for example, these client due diligence, designated director. So as every reporting entity has to designate a director and report it to the authority that this is the principal officer or designated director. Now, do you think is it practical for all practicing firms to designate a director? And when we also talk of transactions of suspicious transactions, in the banking context, it is easy to understand that if there's a cash transaction above 10 lakh rupees in a month, you report it to the FIU by way of monthly returns. But here, on the practicing side, who are just directors in companies or maybe creating a company or managing a company, they may not have access to the financial books of accounts or records or bank account. So how can all these transactions be reported where they may not have even access to it?
I think this question is really meant for Vijay ji, because I am giving highlight on that designated director. One of the section talk about that all obligation for the compliances is casted on the designated director, so that in the litigation he can't deny that I am not aware of PMLA. I have not taken a trainings. I have not given a trainings to my these supporting staff. And principal officer's obligation is only limited to maintenance of records and reportings. So you can hire within your firm for the reportings and creating the records, but obligation is on the designated director, because he is having the ultimate powers for controlling the affairs of that particular firm. And in litigations, again, we are mentioning and quoting the same thing. You can't deny that I am not aware that how this property bought by my client or my relatives. So that kind of questions will come on designated director.
Surely. Any last words from you, Mr. Dalmia, on PMLA and the recent notifications?
As far as PMLA is concerned, it is a very important law, and one must definitely take care not to get involved with the PMLA activities, because it not only results in criminal prosecution, but it also economically ruins the person who is involved in the PMLA activities. Because there is a confiscation, attachment of the properties, taking possession of the properties, confiscation of the properties. And at least I can tell you, I have seen the clients who are coming to me with thousands of crores of rupees worth PMLA allegations and saying that they don't have the fees to pay me. So that is the kind of disaster they may face.
Yeah. You should start charging your fees, Mr. Dalmia, as a percentage of the offense, offense, the fee involved in the offense.
That is not allowed in India. That is not legally allowed.
Understand. Okay, Somesh, any last words from you on PMLA and the recent notifications?
I already mentioned, Sumit, you need to combat. Combat is, you need to play like in a Virat Kohli on the front foot, not on the back foot. So obviously you need to challenge before you are taking any assignment from the client. Yes, these are the requirements from the government of India. We need to follow, and we will play and we will work on the front foot only. We are not the ones, we are not the practicing professional. We are just hungry for the work. We are following the compliances, obligations of the PMLA, and we are working with foreign clients. Obviously we need to take good certificates, character certificates from foreign respective countries also of that particular client.
Right. From my side, I think I would like to sum up saying that we should not be totally scared. We just need to be a little more vigilant. By we, I mean people who are dealing with their clients and incorporating companies, acting as directors, or giving their offices as registered offices. Per se, these activities are not banned or bad. However, what is required is the KYC to start with. So the Act very clearly now says that as a reporting entity or as an entity covered under PMLA, before we start engaging with any client, we need to not only obtain, if it's a corporate client, their MOA, AOA, board resolutions of the companies. Also look at the beneficial owners who are the ultimate shareholders of that company and obtain their passports if it's a foreigner, etc. Or in case of Indian, PAN card, Aadhaar card, etc. So first of all, the KYC is the bare minimum that we need to start with. I don't know whether we'll have mechanisms to validate or verify, as Somesh was saying. But even if the mechanisms don't exist, obtaining a self-certified KYC is the step in the first direction. If you can do a face-to-face meeting with the client, go ahead and do that. Talk not just about your assignment, but also about the business of the company, the headcount, the turnover, the locations, the background, the history. Look at the website and maintain these records for your own KYC purpose. That is the first thing. So, and also a basic due diligence on the compliances or non-compliances, any show cause notices have been issued, any litigations going on. So basic due diligence before we onboard any client so that we work with the compliant clients. I think this is the first message by virtue of these notifications. Second, even when we are lending the registered office, etc., there has to be a proper agreement, either a lease deed or a leave and license agreement, rental paid through banking channels, TDS deducted. So then lending the office is per se not bad if all the compliances and all the paperwork and documentation is in place. Similarly, if you're a director, if you are actually sitting in the board meetings, taking a sitting fees or a professional fees, contributing, and if you come across any suspicious transaction by virtue of your being on the board, and if you're either escalating, reporting to the board, to the audit committee, or to the authorities under PMLA, or maybe stepping back and resigning in case you feel smell any rat over there. I think these are some basic fundamental things that professionals should do. Even on the employment side, if you're the CFO, company secretary, chartered accountant, PMLA or non-PMLA, we know, I mean, we don't need to look at all the 50 pages of schedules to see what is an offense, what is not. We know what are offenses. Fraud under Companies Act, we don't need to really read that schedule to see what is fraud and what is not fraud. So I think hand on our heart, if there is a suspicious, fishy transaction, if we as a conscience keeper or a flag bearer or a torch bearer, put our foot down and refuse to sort of concede in as a practicing side or on the employment side, I think we will be doing what is expected of us to do. And then the EDs and the directors and the other administrative and judicial authorities, whenever they knock your door or our doors, if you have sufficient evidence to tell that, okay, you did your due diligence, you exercised all the basic care, despite that, if somebody without your consent or connivance is undertaking a money laundering transaction, you may not be held responsible.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.